Welcome back to Martinez Law Center. I'm here to break down California's rent control laws that every landlord needs to understand in 2025. As tenant advocates, we see these violations daily, so let's get into the critical details. First, let's talk about AB 1482, California's statewide rent control law. This applies to most rental properties and caps annual rent increases at 5% plus the local consumer price index, or 10% maximum, whichever is lower. But here's what landlords often miss. This only applies after tenants have lived there for 12 months. Now, notice requirements are crucial. For rent increases of 10% or less, landlords must give 30 days written notice. For anything over 10%, it's 90 days. The notice must include specific language stating that California law limits rent increases and reference Civil Code Section 1947.112. Let's discuss just cause evictions. After 12 months of tenancy, landlords can only evict for specific reasons. At-fault causes include non-payment or lease violations, but tenants must get a chance to fix the problem first. No-fault evictions like owner move-ins require relocation assistance. That's 1 month's rent the landlord must pay. Here's where many landlords trip up. Exemptions. Single-family homes and condos not owned by corporations are exempt, but only if tenants receive written notice. Buildings less than 15 years old are also exempt, and this rolls forward each year. Local ordinances can be stricter than state law. Cities like Los Angeles, San Francisco, and Oakland have their own rules that often provide more tenant protections. The Costa-Hawkins Act limits some local controls, but allows vacancy decontrol in most cases. Security deposits are now capped at 1 month's rent for most properties as of 2024 and must be returned within 21 days with itemized deductions. Starting April 2025, landlords must offer to report on-time rent payments to credit bureaus. Landlords cannot retaliate against tenants for complaints or evict to circumvent rent caps. Violations can result in tenants recovering overcharged rent plus interest, and courts may order tenant reinstatement. Remember, habitability is non-negotiable. Properties must maintain safe conditions with functional utilities and no health hazards. Failure to address repairs can lead to serious legal consequences. The key takeaway? Document everything. Provide proper notices and understand that local laws may be more restrictive than state requirements. These protections exist until 2030 unless extended.
Call now 714-442-9741. Thank you.